When it comes to financial responsibilities in old age, one of the most misunderstood areas is medical and credit card debt after the death of a family member. Seniors often feel pressured by debt collectors, letters in the mail, or even subtle guilt trips from companies that want to recover money quickly. However, the truth is that seniors are not automatically liable for these debts unless they specifically co-signed or are joint account holders. This means if a parent passes away with outstanding hospital bills, or if a spouse dies leaving behind a credit card balance in only their name, the surviving family members are not legally required to pay from their personal funds. The debt becomes part of the deceased's estate, and creditors can only attempt to collect from whatever assets the estate holds, such as savings, property, or other belongings that legally belong to the deceased. Once the estate is settled and if there is no money left, the debt is written off, not passed on to loved ones. The reason for this protection comes from consumer laws designed to prevent unfair financial burdens. For example, credit card companies willingly take on risk when they extend credit to individuals, and they know that death is one of those risks. That is why they often charge high interest rates. They balance the profit against the chance that some debts may never be recovered. Likewise, hospitals and medical providers know that not every bill will be paid in full, especially when a patient passes away without leaving behind sufficient resources. Unfortunately, debt collectors often rely on ignorance of the law. They call grieving families and strongly imply that someone must step up and pay. They may even use threatening language or try to shame seniors into paying a loved one's debt. But unless the senior legally co-signed a hospital admission form or a credit card application, these bills are not their responsibility. Co-signing, however, changes everything. If a senior signed a document agreeing to be responsible for another person's debt, then legally they can be held accountable. This could happen in the case of medical care where a spouse or child signs as a guarantor, or with a credit card account that has joint ownership. Joint account holders are different from authorized users. An authorized user is simply someone who uses the card but is not legally responsible for repayment. A joint account holder, on the other hand, shares equal responsibility for any outstanding balance. For instance, if a husband and wife have a joint credit card and the husband dies, the wife remains fully responsible for the balance. But if it was only in the husband's name, the wife owes nothing unless she co-signed or agreed to be a guarantor. Medical debt works in a similar way. Hospitals may present paperwork during an emergency or admission that includes clauses making a relative responsible for the patient's bill. It is important for seniors to carefully read such documents before signing because once signed, they can be held liable. Without such an agreement, however, the debt is attached only to the estate of the patient who received care. If the estate cannot cover the bill, the hospital must write it off. No child, spouse, or sibling is automatically required to pay. In some cases, hospitals even attempt to bill family members under vague, filial responsibility laws in certain states or countries, but these laws are rarely enforced and can often be challenged in court. Seniors should seek legal advice if they feel pressured under such circumstances. The emotional aspect of this issue is equally important. When a loved one dies, families are in grief and may not have the strength to resist persistent collection attempts. Seniors may feel morally obligated to pay, even when they do not have to. Creditors exploit this sense of duty, making calls that sound official and urgent. It is essential for seniors to understand that choosing not to pay a debt that does not legally belong to them is not dishonorable, it is simply exercising their rights. Their financial security in retirement should come first. Money spent unnecessarily on someone else's debt could mean less for healthcare, food, or housing in their own old age. Protecting personal stability is not selfish, it is necessary. Another layer of protection is provided through federal and state consumer protection laws. In many countries, debt collectors are prohibited from harassing or misleading consumers. For example, in the United States, the Fair Debt Collection Practices Act (FDCPA) makes it illegal for collectors to threaten family members with legal action if they are not responsible for the debt. Seniors can request that all communication stop, and collectors are required to comply. They can also ask for proof of the debt and their own legal responsibility for it. In many cases, the debt collector will be unable to provide such proof, confirming that the senior is not obligated to pay. There are also financial strategies that can help avoid confusion. Seniors should keep their accounts separate from their children's or spouses unless there is a good reason to share. Avoiding joint accounts or unnecessary co-signatures helps ensure that debts remain tied to the individual who incurred them. Families should also have open conversations about debt responsibilities, wills, and estate planning. Understanding who owns which accounts and ensuring that medical paperwork is signed correctly can prevent future complications. Seniors may also benefit from consulting an elder law attorney, who can clarify responsibilities and offer legal protections against aggressive collection practices. A real-world example illustrates this clearly. Suppose a senior's adult son passes away with $50,000 in hospital bills and $10,000 in credit card debt. The son lived independently and never asked his parent to co-sign anything. The hospital and credit card company may contact the parent, saying payment is needed. But legally, the senior owes nothing. The creditors can only file a claim against the son's estate. If the estate has a car worth $5,000 and savings of $2,000, creditors may recover that $7,000, and the rest is written off. The parent does not have to use personal funds or retirement savings. Sadly, many seniors do not know this and may pay from their limited income, causing unnecessary financial stress. On the other hand, if the same senior had co-signed the hospital admission or held a joint credit card with the son, the responsibility would fall partly on them. This is why understanding the difference between co-signing and sole responsibility is critical. Awareness protects seniors from being manipulated or tricked into obligations they do not legally owe. Old debts that have passed the statute of limitations are one of the most confusing areas for seniors, because debt collectors often use legal-sounding language to make them believe they still owe money. In reality, once a debt reaches the expiration period set by law, creditors cannot legally sue to collect it. Each region or country has its own specific time frame for different types of debts, but the idea is the same everywhere. The law gives creditors only a limited number of years to take formal legal action. After that, the debt is considered time-barred. While collectors may still contact a person to request payment, the debtor has every right to refuse without fear of legal punishment. For seniors, this protection is especially important because many old debts resurface when they are least able to pay, and without this safeguard, they could be driven into unnecessary financial hardship. The statute of limitations varies depending on the type of debt. For example, credit card debt may expire after 3 to 6 years in many jurisdictions, while medical bills or personal loans might have slightly different time frames. Mortgage-related debts or tax obligations may have longer limits. What matters most is the date of the last activity on the account, such as the last payment or the last acknowledgement of the debt. Once that period passes, creditors lose the right to sue. This does not mean the debt disappears entirely. It still exists in records, and collectors may still ask for it, but the senior has the legal shield of knowing that no court can compel them to pay. If a lawsuit is filed after the statute of limitations, the case can be dismissed simply by pointing out that the debt is time-barred. The danger comes when seniors, unaware of this law, make small payments or promises. Even a token payment of a few dollars or a verbal acknowledgement can restart the clock on the statute of limitations, a process sometimes called re-aging the debt. Collectors know this and may trick seniors into making a good faith payment. Once restarted, the debt becomes legally collectible again, and the creditor may file a lawsuit. That is why it is critical for seniors to be cautious when speaking with debt collectors. Instead of agreeing to pay immediately, they should first request written proof of the debt, including the date of the last payment, to confirm whether it is still legally enforceable. If it is time-barred, they should avoid any action that might restart the timeline. Debt collectors often rely on fear and confusion. Seniors may receive official-looking letters suggesting legal consequences, or phone calls threatening garnishment of wages or seizure of property. In most cases, these threats are empty when the debt is past the statute of limitations. Collectors are banking on the fact that seniors do not know their rights. Understanding these protections helps seniors stand firm. They can respond with a simple letter stating that the debt is time-barred and that they do not wish to be contacted further. Many consumer protection laws also require collectors to stop communication once such a letter is received. This provides peace of mind and prevents ongoing harassment. One of the most powerful tools seniors have is knowledge of their jurisdiction-specific laws. In the United States, for example, the statute of limitations for credit card debt is often between 3 and 6 years, depending on the state. In some places, it may extend to 10 years, but rarely longer. In Canada and the United Kingdom, similar rules exist with variations in the length of time. Seniors should check the exact rules in their country or state to know their rights. Understanding this timeline allows them to evaluate any demand letters they receive. If the debt is too old, they can rest assured that the law is on their side. There is also an emotional component to old debts. Many seniors grew up in an era when paying every bill was a matter of personal honor. Even when they legally owe nothing, they may feel guilty about not paying. Collectors know this and may exploit those feelings, suggesting that failing to pay will affect their credit score, harm their reputation, or burden their family. The truth is that after many years, the impact of an old debt on credit reports often disappears as well. Most credit bureaus stop reporting debts after 7 years, which means these old debts may not even appear on a credit file anymore. Seniors should remind themselves that financial institutions take calculated risks, and when a debt expires, it is part of the system, not a personal failing. An example can make this clearer. Suppose a senior took out a personal loan 12 years ago and made payments for 2 years before financial difficulties caused them to stop. The creditor made some collection attempts in the first few years but then stopped. Now, over a decade later, a debt collector contacts the senior, demanding payment and threatening legal action. The senior, if uninformed, might panic and agree to a small payment plan. That payment would restart the statute of limitations, giving the collector the power to sue legally. But if the senior knows the law, they would instead request written proof of the debt's age. When the collector fails to provide evidence within the legal time frame, the senior can confidently refuse to pay, saving themselves from unnecessary financial loss. Another key point is that debt collectors often buy old debts for pennies on the dollar. When the original creditor gives up, they sell the account to a collection agency. That agency hopes to collect even a fraction of the balance and still make a profit. This explains why they pursue even very old debts. They only need a few people to pay to make it worthwhile. But legally, they cannot force payment if the statute has expired. Knowing this helps seniors see the situation differently. The collector is taking a gamble, not enforcing a legal obligation. Seniors should never feel guilty for refusing to pay money they no longer legally owe. To protect themselves further, seniors should avoid giving out personal banking or credit information to collectors. Unscrupulous agencies sometimes engage in aggressive tactics, including unauthorized withdrawals or repeated calls. The safest approach is to communicate in writing, keep records, and never agree to payment over the phone. Seeking advice from a consumer rights attorney or nonprofit credit counseling service can also provide guidance. These professionals can quickly determine whether a debt is time-barred and help draft letters that stop harassment. It is also important for families to support seniors in these situations. Adult children or trusted relatives should help review any suspicious letters or calls to ensure the senior does not fall victim to intimidation. Scammers often target older adults with fake collection notices, pretending that old debts exist when they never did. Having a second set of eyes helps prevent mistakes and protects the senior's finances. In summary, old debts that exceed the statute of limitations cannot legally be enforced through the courts. Seniors are especially vulnerable to manipulation in these cases, but the law is designed to protect them. The debt remains on paper, but it is no longer a threat. Seniors must be cautious not to restart the timeline by making small payments or acknowledging the debt. They should demand proof, know their rights, and communicate in writing. By doing so, they can shield themselves from unnecessary stress and preserve their financial security. Understanding this principle allows seniors to focus on their well-being, free from the burden of debts that legally belong to the past. When it comes to marriage and financial obligations, one of the most common misconceptions among seniors is the belief that a spouse's individual debts automatically become the other partner's responsibility. This misunderstanding often leads to unnecessary fear and financial strain, especially when one spouse passes away or struggles with unpaid bills. In truth, debts are personal legal obligations. If a loan, credit card, or medical bill is solely in one spouse's name, the other spouse is not legally bound to pay it unless they signed as a co-borrower, co-signer, or guarantor. This principle is crucial for seniors to understand because it prevents them from being manipulated into paying debts they never agreed to. The law separates individual financial contracts, and just being married does not mean you inherit or absorb the other person's liabilities. The distinction begins with how the debt was created. When a person applies for a loan or credit card, they enter into a contract with the lender. That contract identifies the borrower and binds them to repayment. If the other spouse did not sign that contract, they are not a party to it and therefore not responsible. For example, if a husband applies for a personal loan in his name only and later cannot pay it back, the lender can pursue him and his assets but cannot automatically force the wife to pay. Similarly, if a wife opens a credit card in her name alone, racks up a balance, and later passes away, her husband is not personally obligated to settle that bill from his own income or savings. The creditor may attempt to collect from her estate, but the surviving spouse's separate assets remain safe unless joint ownership is involved. This distinction is especially important in old age because debt collectors often prey on widows and widowers. After the death of a spouse, collection agencies may call the surviving partner, implying that they now owe the debt. They use emotional pressure during a vulnerable time, hoping the grieving spouse will pay to avoid conflict. Many seniors, unaware of their rights, hand over money they never owed. The truth is, unless the surviving spouse was a joint account holder or co-signer, the debt belongs solely to the deceased's estate. The estate may pay if it has assets, but if not, the debt simply dies with the borrower. The surviving spouse's personal bank accounts, pensions, and savings remain untouchable. However, there are exceptions in specific legal systems. In community property states or countries, spouses may share responsibility for debts incurred during the marriage, even if only one spouse signed. For instance, in some parts of the United States, community property laws dictate that debts acquired during marriage are considered joint, regardless of whose name is on the account. In those cases, creditors can sometimes pursue the surviving spouse. But even within those laws, there are protections and limits. Not all debts qualify, and many assets are shielded. Seniors living in such areas should seek legal advice to understand exactly how community property rules apply to them. Outside of those exceptions, the general rule holds strong. One spouse is not liable for the other's individual debts. Another important point is the difference between co-signing and being an authorized user. Seniors often confuse these roles. If a spouse is listed as a co-signer or joint borrower, they share equal responsibility for the debt. This means if one spouse stops paying, the creditor can pursue the other. By contrast, if a spouse is merely an authorized user on a credit card, they have the ability to use the card but are not legally liable for repayment. Authorized user status does not create debt responsibility. This distinction protects many seniors who may have been added to their spouse's credit card simply for convenience but never signed a contract agreeing to pay. When the primary cardholder passes away, the authorized user is not responsible for the balance. Medical bills create a similar area of confusion. Hospitals may sometimes claim that a spouse must pay for their partner's treatment. While it is true that some states have laws imposing a duty of support between spouses, these laws vary greatly, and in most cases, they do not override the basic principle of personal debt responsibility. If a senior did not sign as a guarantor for their spouse's medical care, they generally cannot be forced to pay. Some facilities may pressure the healthy spouse to sign paperwork during a crisis, making them liable without fully realizing it. This highlights the importance of carefully reading hospital admission forms and refusing to sign unnecessary guarantees. The emotional side of this issue is just as significant as the legal side. Many seniors feel a moral obligation to pay their spouse's debts, even when they are not legally required to. Creditors often exploit this sense of duty, using phrases like, "honor the memory of your spouse," or suggesting that non-payment could tarnish their partner's reputation. Seniors need to understand that these are manipulative tactics. Protecting their own financial security is not dishonoring their spouse, it is safeguarding their future. Retirement funds, pensions, and savings are meant to support the living spouse's well-being, not to be drained away by debts they never agreed to take on. A real-world example makes this clear. Imagine a wife passes away leaving $20,000 in credit card debt that was solely in her name. The credit card company calls her husband, urging him to pay. The husband, grieving and feeling pressured, believes he must cover the balance. But legally, he owes nothing unless he co-signed. The credit card company can file a claim against the wife's estate, but if the estate has no assets, the debt is erased. The husband's retirement income, house, and savings remain his. If he pays voluntarily, he sacrifices his financial stability for a debt he never had to cover. For seniors, the practical step is to know their rights and set boundaries. When contacted by creditors about a spouse's debt, the correct response is to ask for written proof of responsibility. If the debt is not in their name, they can refuse to pay. It is also wise to communicate only in writing and avoid making any promises over the phone. Seniors can further protect themselves by consulting an elder law attorney, who can confirm their lack of liability and send cease and desist letters to aggressive collectors. These steps not only prevent financial loss but also provide peace of mind. Family conversations also play a role in preventing confusion. Spouses should discuss their debts openly and avoid co-signing for loans or credit cards unless absolutely necessary. Clear estate planning can also reduce complications. Wills, trusts, and properly titled accounts help ensure that debt stays separate and assets are passed smoothly to the surviving spouse without entanglement. The more transparent a couple is about their financial arrangements, the harder it becomes for creditors to manipulate the survivor after one partner's death. When seniors or their families deal with nursing homes and long-term care facilities, one of the most common financial fears is the cost of care. Nursing home bills can be extremely high, often running into thousands of dollars per month, and families worry about being personally responsible. Many people believe that if a parent or spouse cannot pay, the nursing home will automatically turn to the children or relatives for payment. In reality, family members cannot be forced to pay nursing home bills unless they signed a binding contract agreeing to it. This legal protection exists because nursing home care is a service provided to the individual receiving treatment, and responsibility for payment belongs to that individual or their estate, not automatically to their relatives. Understanding this distinction is vital for seniors and their loved ones because it prevents unnecessary financial strain and protects family relationships from being strained by debts that do not legally belong to them. The way nursing homes operate financially is straightforward. When a resident is admitted, they sign an agreement promising to pay for their care, either personally, through insurance, or with government assistance such as Medicaid. If the resident is unable to cover costs, the facility can pursue payment through the resident's assets or apply for Medicaid on their behalf. What they cannot legally do is shift the burden to adult children or spouses unless those relatives voluntarily signed paperwork accepting responsibility. Unfortunately, in practice, many nursing homes try to bypass this rule by slipping clauses into admission forms that relatives sign during stressful moments. For example, when admitting an elderly parent, a son or daughter may be asked to sign documents as the responsible party. If they do not carefully read the fine print, they might unknowingly agree to be financially liable for thousands of dollars in future bills. This is why legal experts consistently advise families to be very careful when signing nursing home paperwork. If a child or spouse must sign on behalf of a resident, they should do so only as a representative, or power of attorney, not as a guarantor. Signing as a representative means they are simply helping the resident complete paperwork, not taking on financial responsibility themselves. Nursing homes sometimes blur this line intentionally, hoping to gain a financial safety net. Once a relative signs as a guarantor, the facility has the legal right to pursue them for unpaid bills. Without that signature, however, the law is clear: family members cannot be held liable. Another area of confusion comes from so-called filial responsibility laws. In some states or countries, there are old laws that technically say adult children can be required to support their parents if the parents cannot afford care. While these laws exist on paper, they are rarely enforced and often challenged successfully in court. Modern healthcare systems and government programs like Medicaid are designed to cover such situations, making it highly unlikely that a family member will ever be forced to pay under filial responsibility statutes. Nonetheless, nursing homes sometimes cite these laws when pressuring families, even though the legal basis is weak. Seniors and their children need to know that such threats are often more bark than bite. It is also important to understand how Medicaid interacts with nursing home costs. Medicaid is a government program that covers long-term care for seniors who meet financial eligibility requirements. When a senior's income and assets are too low to cover nursing home costs, Medicaid steps in to pay. Nursing homes are required to accept Medicaid once a resident qualifies. Some facilities, however, may delay or discourage Medicaid applications, hoping to pressure family members into paying privately for as long as possible. This is why seniors and their families must learn how to navigate Medicaid rules and apply as early as possible. Once approved, Medicaid covers ongoing costs, removing the burden from both the resident and their relatives. Real-life scenarios highlight the importance of these protections. Suppose a father enters a nursing home and signs the admission contract himself. After several months, he runs out of money and owes $20,000. The nursing home then contacts his daughter, claiming she must pay. Unless the daughter signed as a guarantor, she has no obligation. The facility must attempt to collect from the father's remaining estate or help him transition to Medicaid. If the daughter gave in and paid from her savings, she would be sacrificing her own financial security unnecessarily. The correct step would be to refuse liability and remind the facility that only the resident or Medicaid is responsible. Another scenario is when a spouse admits their partner to a nursing home. The facility may pressure the healthy spouse to sign as a guarantor, especially if the couple shares financial accounts. In most cases, the spouse is not automatically liable unless they signed. Community property laws in certain regions may create some shared responsibility, but even then, there are limits, and the spouse has legal defenses. The safest approach is to sign documents only as a representative or agent under power of attorney, never as a personal guarantor. This prevents the nursing home from pursuing the healthy spouse's assets later on. Debt collectors working on behalf of nursing homes also use aggressive tactics. They may send letters suggesting that children are morally obligated to pay or that failure to pay could harm their parents' care. These tactics are designed to intimidate and guilt family members into giving up money. Legally, the facility cannot refuse care to a resident already admitted because of unpaid bills, nor can they harass relatives who are not responsible. Families facing such harassment can file complaints with consumer protection agencies or consult elder law attorneys to put a stop to it. Knowing these rights allows seniors and their children to stand firm without fear. The emotional burden of nursing home costs cannot be ignored. Families often feel torn between wanting the best care for their loved one and fearing the bills that follow. This emotional stress is compounded by misleading information from facilities. By educating themselves in advance, families can avoid being trapped by guilt or misinformation. Seniors deserve proper care without their children losing homes or retirement savings to cover costs they do not legally owe. Protecting family financial security is part of ensuring long-term stability for everyone involved. The best defense against unexpected liability is preparation. Families should talk openly about long-term care plans before a crisis arises. Seniors can work with attorneys to establish powers of attorney and clarify who will manage financial matters if they cannot. They can also explore long-term care insurance or Medicaid planning strategies to ensure coverage when needed. When admission to a facility becomes necessary, relatives should carefully review every page of the contract, cross out any clauses making them guarantors, and sign only as representatives. Taking these steps prevents unpleasant surprises and secures legal protection. In summary, family members are not legally required to pay nursing home and care facility costs unless they willingly signed a binding contract. Nursing homes and their debt collectors often use pressure, intimidation, and legal half-truths to convince families otherwise, but the law is on the side of the relatives. The responsibility lies with the resident's own assets and government programs like Medicaid, not with children or spouses who never agreed to take on the debt. By staying informed, refusing to sign unnecessary guarantees, and standing firm against harassment, seniors and their families can protect both their loved ones' care and their own financial future. This knowledge frees families from fear, allowing them to focus on what matters most: ensuring the senior receives quality care and comfort in their later years without leaving others unfairly burdened by debt.